My name is attorney Cynthia Petruka, and I'm an employment lawyer based out of Illinois. I'm here to talk about three things you should know about collecting severance pay. The first thing I want to say is a disclaimer. What I'm talking about here is not legal advice. This video is for informational purposes only, and you should definitely hire a local employment attorney if you need to get legal advice about your specific case. Now, there's three things you want to focus on when you're reviewing your severance agreement. The first thing is deadlines. The second thing is unemployment benefits. And the third thing is confidentiality. Obviously, the big thing I'm leaving out here is the actual amount of pay. That is something that I will discuss in another video. Today, I'm just going to focus on these three topics. When it comes to deadlines, it really depends on how old you are. I get a lot of questions from my clients. Well, how much time should I be getting? What's legal about how much time I get to review my severance agreement? And it really depends on your age. If you are under age 40, you don't have the same protections that somebody age 40 plus has. And so a company can, if you're under age 40, make you sign a severance agreement immediately. Sometimes I hear within 7 days, any time period the company wants. But if you are 40 years or older, you have to be given at least a minimum of 21 days. Why? Because there's a law called the Older Workers Benefit Protection Act that governs how much time older workers, and you're considered older when you reach age 40 plus, are supposed to get. So if you're age 40 plus, understand that if your employer has given you less than 21 days, for example, sometimes I see my clients get 7 days. And the first thing I do when I reach out to an employer is say they're supposed to get a minimum of 21 days. Make sure that you get that. You can negotiate that on your own or with an employment attorney if you choose. The other thing you should understand, if you are age 40 plus, you also get some time on the end of signing your agreement. After you sign your agreement, if you change your mind, you actually get 7 days to revoke your agreement. This also comes from the Older Workers Benefits Protection Act as well, and gives you the extra time to really consider and think about your severance so that you're not stuck with something you don't like. The second topic I want to talk about is unemployment benefits. Because I'm an attorney out of Illinois, I'm going to talk about Illinois specifically. In Illinois, you can collect severance pay and unemployment benefits simultaneously. Now, a lot of my clients that come to me will have agreements that say something to the effect of, if you collect the severance pay, you're not allowed to collect unemployment benefits. That is a private agreement you can make with the employer, but I always try to get that removed from the requirements. I like my clients who are going through a very difficult time losing their job to make sure that they're collecting as much money as they can, whether that be through unemployment benefits, severance pay, or both. In Illinois, amounts paid or payable to the individual as severance pay shall not render the individual ineligible to receive benefits. The Illinois Department of Employment Security really looks to the nature and the purpose of such payments rather than their characterization. So sometimes, for example, I'll see agreements where my clients are not paid lump sum severance amounts, they're paid continuation on the payroll schedule. And just because you're still on the payroll schedule doesn't mean you're a bona fide active employee collecting wages. So understand that the unemployment office is likely to look at the nature and the purpose of those payments rather than what they're actually called. The last thing I want to talk about is confidentiality, and this is really important. It's really important that you understand that when you get this severance package, you have to keep the terms of the severance pay confidential. So you can't tell coworkers that you used to work with, you can't tell your friends. Who can you tell? Well, typically when we see these types of agreements, there's a carve out exception for who you can tell. You're not allowed to tell anybody except for your spouse, your attorney, your accountant, and a government official during an investigation. And what does this mean? You're not supposed to be telling your friends. You're not supposed to be telling your boyfriend. You're supposed to be really honing in only on the people in your close circle or government investigators that need to complete an investigation. Thank you for tuning in to the Worker Value Shows, and continue choosing your values over a toxic work culture.